Hello, everybody. My name is Robert Ward. I will be hosting this webinar along with Robin Bonas. He is GDPR Brain. Okay. I see a few people are already having a chat, a bit with me, a bit amongst themselves. Just going to ask if you cannot hear me, only if you cannot hear me, can you please just pop something in there and say something nice so that we can just check our audio or your audio. I believe everything should be fine, but like I said, just give people the opportunity. Maybe a shark has cut a wire or something like that, Johnny. I don't know. Okay. I think everybody can hear us. Right. So today we are T-minus a while away from GDPR.
About 7 weeks today, I think it is.
7 weeks. Thank you very much. Robin is the brains of the operation today. Okay. Some of you will know. I just show how the system works. I'm not overly technically minded, but that's why Robin is here. So Robin is going to be able to help answer sort of questions like the questions that you can see in front of you, and feel free at the during the webinar. There is a little should be around there, somewhere around there. Ask a question. So if you want to ask a question, pop it in there. Okay, I have some questions from some people who couldn't attend, so I will go through them at the end anyway. But ask a question, and we will get to it at the end if we haven't already gotten to it during the webinar. Okay, so as you can see there, we're going to go through a couple of questions. We're going to have a look, or a couple of points really. We're going to have a look at how eBoss works, okay, and how it can help with compliance. And then we'll do a Q&A. You might consider that there's a lot to take in this webinar, but what we'll be able to do is, for the people who've attended, we will be able to email you out these slides so you have them, okay? The other thing is this webinar will be on our website forever, okay? So you will be able to watch, or until we do a better one, but you will be able to watch that at your leisure. And I understand from a conversation I had with Robin earlier on, you can now use attendance of this webinar as evidence that you have attended training. Is that right?
Only if the webinar is good.
Only if the webinar is good. Okay. Well, that'll remain to be seen. So, without further ado, I shall ask the first question and then pass over to Robin. Robin, why is GDPR important to recruiters?
Thanks, Rob. We'll start with the basics then, and we have the 4 points in front of us there. Why is GDPR important to recruiters? Because it's important to everyone. As we've all heard 1,000 times before by now, GDPR, the General Data Protection Regulation, is the first piece of data protection regulation that has a global reach. It means that EU citizens' data is protected and the use of it is limited regardless of where your company is based. You don't even need a premises in the European Union to be affected by GDPR. Second point, recruiters hold a large volume of personal data by the very nature of their business. And that data is vital to recruiters' business interests. If you think of a retailer, then if a retailer doesn't bring their data into compliance, they may not be able to use it, but they can continue to sell goods and products, and they can collect new data if it's legally compliant. If a recruiter's database is not compliant, then they have no product. It's equivalent to a retailer losing all of their stock. So in that sense, GDPR is of particular significance to recruiters. And I think that we've seen, just from anecdotal experience, that recruiters are taking this seriously compared to a lot of other industries and sectors. And finally, another point that everyone is probably familiar with, getting it wrong can be a very expensive mistake. A serious breach of data security can result in a 10 million euro fine, or 2% of your annual turnover, or a particularly serious infringement can double that fine. So if regulators believe that infringement was deliberate or malicious, then you could be looking at a 20 million euro fine, which obviously has to be taken seriously.
Okay, so I don't want anybody raiding my piggy bank for my 20 million that I have stashed away. So if somebody held data, okay, and a candidate went, and I'm putting you on the spot here, Robin, so if you don't know the answer, it's just something that came to mind. So if somebody has data on their system and a candidate didn't give them permission to hold it, okay, can the candidate then bypass our client or any individual that's holding that data, go straight to the ICO and say, this person has got my data and I never gave them permission? What's the situation there? Would it be a case that the candidate would have to request that data is withdrawn, removed from the system, or can they go straight to the ICO?
If they went to the, obviously the law hasn't come into effect yet, so there's no test case for that. But realistically, if they were to do that, the ICO would point them to the data controller, and they would initiate the right to erasure or right to access request in the usual way. So no, there wouldn't be a specific problem where a candidate who had failed to answer a consent request, say. The next thing you hear from...
So basically, there's not going to be the ICO SWAT team bursting down your doors or anything like
absolutely
that?
Absolutely not. Okay. The GDPR isn't a way to try and trick fines out of businesses that are responsible. It's not saying that data breaches in themselves will be illegal and heavily punished in the future. GDPR is just there to get all businesses to act a little bit more responsibly with private data, which is what we should all be doing anyway. Okay,
yeah, and from the conversations that I have had with hundreds of recruiters over the last few months, some having done more research than others, their understanding very much is that the ICO is going to be there to, I suppose, help educate. If you're moving in the right direction, or what you think is the right direction, the ICO, if they were to come in and do an audit, if you got something wrong, they're not going to be slapping a fine on you straight away. It's that whole thing of saying, right, well, you think you're doing it right, but this is what you're doing wrong, and this is what you need to be doing to be doing it right. But case law is a big thing. And on the subject of law, neither myself or Robin are legally qualified solicitors. I know that we have some legally qualified solicitors in attendance in the this webinar. Myself and Robin are not, so please do not quote us or think that what we are saying is law.
Absolutely not. Okay? None of this presentation is legal advice. I'm part of the marketing team at eBoss, but I've also undertaken a lot of the GDPR compliance workload as well. And it might seem like a bit of a strange combination, but in actual fact, it's not so much. We found from experience that marketing is one of the toughest parts of any enterprise to get compliant with the GDPR. Once we had that sorted, I won't say the rest was easy, but it kind of fell into place around the work that we had done based on our marketing activities. So yeah, we are here today to share our own experiences, to explain how eBoss can assist recruiters with their own compliance programs, and just to hopefully start a discussion on the topic.
Okay. So moving on now. What will I need to do to be ready for the changes in the law? Go for it, Rob.
This is almost certainly what people are viewing this, hoping to find out. And I've tried to keep it as broad as possible. Obviously, every company is different in its activities and structure, and some will have important processes that take precedent, whereas others don't. So, first and foremost, recruiters are interested in learning how to bring their database into compliance. As I said before, as a recruiter, your data subject, your personal data, is your product, essentially. You're trying to match candidates to positions, and that relies on a database which you can only use if it's compliant. Now, this is a topic in itself, so we're not going to look in detail at that today. It will form the basis of an entire webinar in the future. So we'll move on to point 2, which is the point we'll look at today, and this is the legal bases for processing your personal data. And in the GDPR, there are 6 legal grounds for processing personal data. There they are. I think you can just see the reference there. It's in Article 6 of the GDPR, and A to F are the reasons. Now, as a recruiter, not all of these will apply. I've highlighted in red the 3 that are unlikely to apply on a wide scale to a recruitment agency. And in many ways, they're not anything that you can plan for either. So you couldn't set out to process your existing database in the public interest or due to a legal obligation. However, it's not to say that they wouldn't apply on a case-by-case basis. But the 3 remaining points that we have are then process based on consent, process based on a contract, and process based on a legitimate interest. For many recruiters, if you have a candidate visit your office, they'll sign up, and they will literally sign up and you will form a contract with them. Now, the good news that recruiters are learning is that a lot of your existing data will be covered by a contract. So your existing database, when GDPR first began hitting the headlines 9 months to a year ago as a time is running out issue for recruiters, the people were worried that they were going to lose their candidates in their database because they were told they'd require consent, when in actual fact, if a contract has been signed and you are using the data to fulfill that contract, i.e. match a candidate with a vacancy, you're absolutely already covered. So in many instances, your contract will form a legal basis. However, GDPR makes legal bases granular. That is to say that each individual use of data has to have its own legal basis. So, for instance, if you have a contract which allows you to process candidate data to find them a job, you don't have a right to send them marketing emails. And so you need to have a different basis for processing their data. And this is where consent and legitimate interest come into play. And consent is, both of these are areas that eBoss has aided our customers in completing their compliance. And the final 2 points, you need a sound understanding of your company's internal processes. And this is really because a lot of compliance work will involve self-assessment, self-reporting. It's a form of self-regulation. So you will have to explain why you use data, how you use it, and that requires an understanding of your business's structure, its purposes, and its interests. Additionally, if as a business you intend to update any of your processes or software or hardware, any of your systems, or introduce new processes or systems, then you will have to establish a legal basis for that. Reporting will play a large part, as with paperwork of all kinds, in GDPR compliance. And so having a sound understanding of what you are doing with data and that you are not overreaching in terms of how you use it, then you should be on the right track. And the final point, this will also form the foundation of a future episode, because it's another big topic with many different factors in play. Need to train staff, and everybody within your company needs to have an understanding of their obligations to data subjects and to data security. So as I say, we'll no doubt be covering that at some length in the future.
Happy days, happy days. Right, so over to me. Now, in terms of people who have who are attending this webinar, I can see there are some clients who already have the GDPR tool. I can see there are some clients who don't have the GDPR tool, and I can see there are some people who aren't yet clients. Okay, so for my customers, our customers who already have the tool, this will be a great little recap. I'm not going to go into it in a huge amount of detail, but the idea is to, and I have to work out exactly how to do this. Done.
I will move mine out of the way.
Just make sure.
Give it another click there. I think we clicked at the same time.
Did we? Okay. I might have to do that again. So just 1 second now. There we are in full HD, everybody. Okay. We did decide that we would have the slot on, or the first screenshot on, because we didn't want to have everybody looking at us for too long. Okay. So we're all good. Okay. So, like I said, this is going to be high level. I'm just going to be explaining to you how our tool works from the front end. Okay. So you can see here we've got a nice dashboard. Okay, and that dashboard is telling you where you are in relation to your candidates and your client contacts. Okay. I know from experience of talking with people, well, customers, potential customers, there is a level of ambiguity around client contacts. Is that personal information, or is it in the public domain? I'm pleased to say I can't give legal advice on that, so I don't know is the answer to that. Is somebody's work mobile also a personal mobile? Therefore, do you have to get their permission? I do not know is the answer. Okay, but that's why we have the contacts in there. Okay, I'm mostly going to concentrate on the candidate side of things before I go into the database and show you what it looks like and the like. We're giving you the back end in order to be able to create your own template communication with your candidates. Okay, so if you want to pitch it that you've got loads of jobs available, and if people click on this link, they'll be able to get those jobs. You can do that. If you want to go down the very safe route of saying GDPR, explaining a little bit about that, you can do that as well. We're leaving it blank. We're leaving it up to you to decide what's best. What's the best approach that's going to work for you guys. Okay, so this table here is showing what your progress level is. Okay, now we are 6th of April, so we still have a lot of candidates who we have done nothing with. Okay, and we also have candidates who have rejected permission, so we should take them off the system, but this is for demonstration purposes only, so that's why they're there. So the system is showing me I've requested permission for 13 candidates. Okay, there's also a section here so that if you decide to go for 1 year, 2 years, 3 years, 5 years compliance, candidates will start to fall into that field here as they get close to their expiry date. Okay, and all you'll have to do is click on the number and then go and communicate with those candidates again. I'll show you how to do that in a second. 5 candidates have rejected permission. Now, these candidates have rejected permission, and I have been asked on numerous occasions, why haven't we deleted the candidates automatically? Okay, we're not deleting them because you may need an opportunity to go back and speak to that candidate to explain to them what they're agreeing to. Sometimes people get so many emails, questionnaires, the like, that they go onto autopilot and they don't know exactly what they're clicking. So we're basically giving you that opportunity before you then go on and delete the information. Okay. We've also got here compliant, limited and compliant. And again, that is around where a candidate may give you permission to hold their data, but if it's limited compliance, based on whatever choices you're giving them in the questionnaire you're sending out to them, they may not give you permission to send them to third parties or to send them marketing communications. Okay, and again, I'll give you a little snapshot of that when I go into the back end. Okay, so let's just say I wanted to see who these candidates were. I can basically click on the number and it'll take me into the candidates page. Okay, and it'll show me who those candidates are. So 13 candidates. So if I wanted, I could select all those 13 candidates and I could go down to GDPR, okay, and I can then say, right, here are all my candidates. I want to send them a text message or I want to send them an email, okay. Either one will have what's known as a webhook, okay. Now, I've gone to this one specifically just to illustrate we are not putting in any content into the email. That is entirely up to yourselves. I'll show you how to do that in the back end. But the great thing with this webhook is that when the candidate gets it and they click on it, when they select their options, it'll automatically update the system. So it's not like you have to have a spreadsheet of, I've sent an email out to these people, some people have come back, some people haven't. It's really just providing you with an automated service where send out the email, candidate comes back. If the candidate doesn't come back, you can go back to your dashboard and you can concentrate on the people who haven't yet responded. Okay, so like I said, it is a very simple, straightforward process, and the great thing is it's the exact same for contacts. You will have a separate candidate template and contact template, but obviously the contact template will only appear in the contact side of the system. With regard to the text messages, you can see here it says please click link. Again, I'll show you in the back end that you can actually put in whatever you want into that section, and the GDPR URL is already included in that communication. Okay, so if I go into the GDPR section here, this is where you can create your emails. So if I go in there, standard thing we're providing you with is the GDPR URL, but like I said, you can go in and form your own letter or your own email in there based on whatever message you want to put in. And then the options here. So these, when we provide this to our clients, our customers, there is placeholder information in there. You do not have to stick with that information, okay? It really is a case of this is good enough, okay? This is good enough, but that's based on what we think. It is not legal advice. It's not legal confirmation that you can just send these out unaltered. You have to make sure that you are happy with the information and the choices that are being given, okay? You've also got then your permission period, okay? If I go into a candidate's record, so let me just go into a candidate's record and show you how it looks inside their file, okay? So if I go into David here, for example, and go into the GDPR section, you can see a few attempts have been made. And that's really why I was asking the question of Robin earlier on. There's nothing to say how long you can keep that data on the system for. So my personal attitude is I'm being seen, or I have been seen, to try and get this person's permission or to get him to withdraw his permission, okay? And I've had to do that 3 times. So you can see in here, I've sent an email, I've sent a text message, whatever. But the great idea, or the idea behind it is, if somebody was to come and visit your office, you can evidence the fact that you are trying to get that candidate to be compliant. So if you do have a lot of candidates on your system who are not compliant, you are evidencing the fact that you are working towards that. Okay. Now, that is GDPR at a very high level of how it works on the system. But the great thing is it's not complicated. And the feedback that we've had from a lot of clients is that it is not complicated. Okay. So there will be, as I'm sure, when the 25th of May comes and somebody has had to provide more clarity on the software, sorry, not on the software, but on the legislation, we will, let me just see, we would probably have to enhance this offering. I'm just seeing Linda has popped a question in there. If someone is highlighted as not compliant on the system, does that stop you emailing them for marketing purposes? Okay, Linda, so if I go back into the GDPR section, and I know I said we'd answer questions at the end, but it's relevant to this very section here. So this person, in order for them to allow you to send them marketing emails and the like, they need to give you permission. Okay, so they need to give you permission to hold their data. Okay, and then it's down to what you put into this second section here, which is where they're saying, I grant full permission. Okay, so in a nutshell, Linda, if somebody is marked as not compliant on the system, does that stop you from emailing them for marketing purposes? Yes, it does. Okay, because you can't have them on the system where they give you the permission to send them marketing emails, but they don't give you the permission to actually hold their data. Okay, so I hope that answers that question. From my perspective, showing the system, I'm sort of done, you know, and like I said, I think the most important thing is, as the legislation not changes but takes shape, and there may be some case laws, if that's the right thing. I'm conscious of the fact that there's solicitors in there. Yeah, it's basically got, look at me, I'm being wrapped up by Robin here. There is, let me just shut that down. Yeah, there is the possibility that things will change in terms of the functionality. Okay, so I hope my contribution to this webinar has been helpful. Back over to you, Rob.
Yeah, absolutely has. Absolutely just want to. So I'm getting my I'll just turn down my speaker. Okay, it certainly was useful, and very early on in that you were speaking about why doesn't eBoss automate the deletion of data if it's non-compliant. And there's an important point in that. The unlawful destruction of personal data is as serious as a data breach. There may be times when a data subject has withdrawn their consent, but for a legal reason, you have to retain that personal data on your system. If it were to be automatically deleted, then that would be a breach almost as serious as publishing it on the internet, say. So that is an important point, and it's something that we took into consideration when we were developing the system. Now, I wanted to explain how we are covering one of the other aspects of legal basis for processing, and that is legitimate interest. And this is the process is perhaps a bit more complex, but our approach has been very straightforward again. It's different to consent because it is not software-based. We've actually put together a free, downloadable, printable self-assessment pack, which you can take a copy of. It's available if you go to our website and you visit the GDPR Hub. You can download it for free there. And it contains
emphasis on the word free.
Flow diagrams and tables and forms which you can complete. When you work through the workflow that we have set out, the end result will be a self-assessment report which should inform your decision on whether you have a legal basis under legitimate interest. It will help you to balance the relationship of interest between yourself as a data controller and the data subject. It will act as official recording. It will demonstrate your compliance and show that you have undertaken the correct work to show a legitimate interest. And that may at times be useful to a recruiter who, for instance, may be attempting to market a new product, a new service, maybe even different roles, which aren't necessarily covered in the candidate agreement that they signed when they visited your office the first time, and they may not have provided a consent. So you can fill out a legitimate interest, demonstrate that the candidate would have a legitimate interest in the new service or product that you're providing, and then you can roll that out with hopefully a greater portion of your database demonstrating compliance. So that almost rounds up how eBoss can assist with your GDPR compliance. There are a couple of other points that I'd like to point out. We have already updated our privacy policy and our cookies and terms of service, and these help you as data controllers demonstrate that you are choosing a service provider, a data processor in eBoss that is compliant, has shown compliance to you, and then you can complete your self-assessment report demonstrating that eBoss is GDPR compliant ahead of the deadline. So I think that ends section 3.
Okay, so I noticed that nobody, I'm amazed, nobody has posted a question other than Linda. Thank you, Linda. You posted it in the chat area. Nobody has posted a question during the meeting or during the webinar. That means that both Robin and I have done a top job. Okay. Couple of things. I have been asked some questions by people who weren't able to make the meeting or the webinar, should I say. So one of the questions was, where are the eBoss servers located? Okay. Now, I could give specifics, but I won't. I will just say they are stored in Europe. Okay. The data never leaves Europe. So therefore, we're conforming to GDPR from that perspective. What happens with GDPR after Brexit, Robin?
Not a lot, especially in terms of the recruiting sector. It's obviously Brexit is a large and complex political issue, and it will require certain unpicking of laws. But because GDPR has a global reach, even if, for instance, UK citizens were to lose their rights as data subjects after Brexit, and that's by no means a certainty, recruiters would still have to demonstrate compliance because the nature of the industry means that you will likely be handling the personal data of an EU citizen, regardless of where you are in Britain. So not a lot. You'll still have to demonstrate compliance.
Okay, cool. I think we may have answered this already during the webinar, but how long do I have to erase the data?
Okay. Yeah, we touched on it in the technical demonstration. I guess there's no set specific date. The law does not say if you have no grounds for processing, you must delete within 14 days or 30 days. There's no specific for that. In some cases, it may be determined by a contract. You may have added a clause in the contract which tells the data subject you will remove their data after 30 days or 365 days of inactivity or no longer having use for it. In other instances, there may be a legal obligation. I think some areas of the financial sector are required to retain financial records for set numbers of years. So there's no hard and fast answer. When you do have to delete data, for instance, under a right to erasure request, then you have to complete the request without undue delay, I think is the way it's worded. Okay. And there's a specific stipulation that neither financial nor technical obstacles are a valid reason for delaying. So if you store and hold on to the data, if you then try to argue it would have cost too much or it was technically difficult to erase the data, they are unlikely to prove good defenses. There's no
okay, yeah, fair enough. Okay, so I'm going to wrap up now. I just want to say a couple of things. One, we have an FAQ section on our website, okay, specifically for GDPR. Two, this webinar will be available on our website for whoever wants to come along and watch it. So you just go along and you can register and watch it at your leisure. We will, to the people who attended this meeting, this webinar, we will send out, you're right to do that, Robin, send out these slides just so it helps people familiar with themselves. Yeah, brilliant. Finally, I would just like to say thank you to all of the people in England, Scotland, Wales, Ireland, loads of places all over Europe, Middle East, and outside of Europe and Middle East and on the other side of the world. I want to thank everybody for attending. Now, the other thing is, just in terms of managing expectations, with the number of people that have attended this webinar, I'm anticipating that people are going to get in touch to ask questions directly to me, whatever. There have been in excess of 200 people on this webinar, so I don't want people to think that I'm going to just be sitting here for the rest of the day able to just respond very quickly. If it takes me till next week to get back to you, please have a little bit of patience. But thank you very much for coming along today. And like I said, I hope it was helpful. Okay, so with that, myself and Rob are going to sign off.
Thanks.
Thank you very much.
Bye-bye.
Bye-bye.